Bien, ces questions matérielles et
So, practical matters are, of course, very important. Now that we have dealt with that, I think we can start with no further ado. There's no reason for me to speak again. You've listened to me enough. I'm simply the clock here, and therefore I shall now hand over to Professor Kolb. I don't think I need to introduce the speakers. They're all extremely well known, and I'm sure they will understand if I don't actually introduce them.
ça fait rien. C'est au maximum, je crois. Et au maximum.
Excellence.
Excellencies, ladies and gentlemen, allow me first and foremost to thank the Academy for this great honor to address you all. Thank you also for yesterday. Thank you so much for allowing me to share a table with Nicholas Politis, thereby allowing me to reconnect with my Greek roots. And just by way of an aside, I would say that Nicholas Politis is as short a man of stature as I am very tall indeed, as you can see. I would also like to thank you very much indeed for putting me pretty much at the beginning of the program. It allows you to overcome the shock of seeing me. I'm more than 2 meters tall. It allows you to overcome that, and later on there'll be other speakers who, I think, in terms of stature, and by that I mean size, will be more adapted to this lectern. Be that as it may, allow me to now give you my address. I, of course, speak from a public law perspective, my familiarity with private law being insufficient for this purpose. Allow me, therefore, to use these few moments to share some thoughts with you that I mulled over on my way to The Hague, on the plane, so to speak. I would like to make first a historical comment regarding public interest. On that point, 19th century, our science at the time was very fragmented, disparate, and it was, if you like, torn this way and that. If you look at old scholarly publications, you can see that there are certain concepts such as unified war. You also see states that develop or discuss rather different statutes of Krakow, just by way of an example. At the time, it was hither and thither. Today, and since then, we have been looking at things more from a Georg Leginek vantage point on law of war. So what was progressive at that time was to, if you like, make public international law more homologous, to try to contract our science, so to speak. We were looking for uniformization of our science. And the underpinning idea was quite straightforward. Today we would say it was too narrow, in fact. At the time, we thought of creating a legal order that was horizontal and that was premised upon the concept of will, the will of states. That was, if you like, the gist of public international law at the time, the most salient aspect. Then, of course, things moved on. There was originally one single pole. That pole organized everything. And that way of looking at things is, I'm sure, a way that you're very familiar with. We've had Trippel, we've had Ancelotti, we've had Erich Kaufmann, perhaps with more original thinking on this aspect, and many other names besides. Now, today, we find ourselves at the beginning of the 21st century, the century thereafter. So this centripetal force unifying international law around just one pole, one axis, that has completely exploded. We are no longer talking about one axis, we're talking about a great many number of different strands. Wolfgang Friedmann was mentioned earlier on. You have, of course, his concept of duality, coexistence, cooperation, to which you could, if you want, add further layers. Differentiations are made, and I'm sure this panel will proceed to do so. Differentiation between so-called private interests and so-called public interests within the corpus of international law. We talk a lot about that. We also talk about hierarchy within public international law. And I'm sure you will have understood that all of these ideas are not at all in sync with the Etherean view that used to prevail, metaphysically speaking, regarding the centrality of the will. Therefore, this morning in our discussions, where we'll be talking about public interest versus other potential interests, I think that this discussion will show that there's been a shift, a paradigm shift. We've moved from one pole to plural poles, pluricausality, all, of course, within a unified system. That was the historical comment I wanted to make. I still have 5 minutes left in terms of speaking time, and therefore allow me to move on to my more analytical point, more conceptual point, if I may. I have tried, at least as best I can, to summarize the different conceptions that we have of the public interest in international law at the beginning of this century. I've done my best to give an overview, and if you really just give an overview, if you really try to be very succinct, you can, I think, identify 3 branches. The first one is the most minimalist one, and some would say it's perhaps the most conservative one. It's also, no doubt, the most long-standing one, the oldest one. And in that school of thought, what we find is that the public interest of the international society is reflected in the existence and the development of international law per se. So in other words, the whole corpus, the whole body of our science in itself represents the public interest. It is the public interest. The existence of this law is a guarantee for order, according to the school of thought, and therefore a shield against anarchy. The rule is there in order to mitigate any selfish individualist excesses on the part of sovereignty, and therefore, in sum, the law is there to civilize us, to domesticate society. Now that in itself is already an effort of civilization, and therefore it falls fair and square within the concept of public interest. Now, during the course of the last century, and still today, people talked of a concert of nations. Well, let me say on that point that international law had definitely lacunae. It was uncertain in terms of some of its foundations, particularly at the time of the League of Nations, or indeed when this academy was first created. And therefore, greater density, increased density, making public international law more dense, that was seen as a giant step towards greater order and greater justice as well. Density was very much a pursuit at the time. Then there's a second school of thought, perhaps more, more restrained, but also more developed in terms of public interest. Here I'm referring to different analytical positions. By way of an example, one could, if one so wishes, redesign the whole body, the whole corpus of public international law, looking at it from the angle or the prism of different perspectives. By way of an example, I would mention this distinction between public law and private law. You could approach it from that angle, and then you could examine certain aspects, certain parts of public international law, or international law, I should say, and you could take a look at that and see whether it's more in tune with private interests, individual interests of states. Is it in the interest of a given state to do this, that, or the other in order to express its sovereignty? And then there are other branches of international law that could be perceived as being more focused on collective, common interests, and what one might call, by way of a shorthand, the international community. So if you look at the law of treaties, you'll see that there is a particular branch that will often be designed to serve private interests, for instance, the expression of particular or individual will, whereas there's also a host of rules, international cooperation, cooperation between states. That body, that flank, if you like, is more of an expression of the public interest, one might argue. Thirdly, and finally, you have a third school of thought, which I think is perhaps the more detailed or the more progressive, if you like, if you wish to call it that. Its purpose is to work very specifically on the public interest, and it is a school of thought that talks about the public international order, public policy, ordre public international. And it, if you like, really influences the development of international law with hierarchies being established. You have some very famous scholars and indeed experts present in this room. You have some courses, general courses, for instance, Carrillo Sanchedo's course, which I think speaks to this very issue, or Rüdiger Wolfrum, who is also, of course, in this panel and who have developed this thought ever further. And it allows us to look at the salient features of these developments, jus cogens, erga omnes obligations, former international crimes and all of their avatars, if I may call them that, Articles 40, Article 41, the articles on state liability, and so on and so forth. Also Actio Popularis, or indeed the extended action articles such as Article 48, or articles that deal with state responsibility, like I said, or indeed the common heritage of humankind, and so on and so forth. So any kind of agreement in rules which is designed to protect the common interest is what we're looking at here. I'm sure you'll have understood that we're going from what was the least specific to the most specific. That is the direction of travel, with a legal order, with provisions that are designed to do the right thing, and very specific instruments to defend the public interest. Ladies and gentlemen, I have exceeded my speaking time by 1 minute. I thank you for your very kind attention.
Merci beaucoup. Une minute pour un Suisse, c'est beau.
Thank you very much. 1 minute for a Swiss person is a lot. For us, it's forgivable. I would now like to give you the floor, sir. Mr. Rüdiger Wolfrum.
Brillant comme toujours.
Professor Daudet, Excellencies, ladies and gentlemen, friends, the panels before me, or the speeches before me, have made my task easier, such as the one of Professor Kolb, or more difficult, like the one of Alain Pelé. And I thought while I was listening to him whether I should change my whole presentation. Perhaps that was his intention, but I will refrain from doing so. Alain expressed himself very clearly about the present situation we are facing, and I put that in front of my presentation, namely the war in Ukraine, but I might add also the war in Sudan. The latter one is hardly ever mentioned. For which reason, I don't know. For it is as dangerous, and for the civilian population as devastating as what is happening in the Ukraine. You may consider me biased, since some of you may know that I've been engaged in Sudan for roughly 20 years. But what we are missing is to do a proper analysis for the reasons of war. Even in Ukraine, we know about what is happening, and that this is aggression in Ukraine and a very strong violation of international law in both cases. The reasons in Sudan are different. And the question is whether, while speaking about ensuring compliance, has something to do with these wars. I must confess the toolkit of international law is not sufficient in this respect, or you could say it otherwise, it's not specific enough to take care of this situation which by Article 2, Paragraph 4 of the UN Charter was meant to be abolished. Having said that, I must engage into a rather technical reference to compliance tools and mechanisms which we have, some of which work perfectly well, others don't. Since Robert Kolb was good enough to explain the common interest well enough already, I don't have to go into details and just step into which control mechanisms and compliance control mechanisms do we have. I don't mention the mass media, although they play a very significant role in this respect, not always a positive one, but occasionally they give us information we are needing. What are the compliance control mechanisms? They are absolutely necessary. We know it even from national law, that a national law which is lacking control and enforcement mechanisms will be, at the end of the day, disregarded. The belief that we believe in the legality or the rightness of law, and this is sufficient, is unfortunately in international law a fiction, and probably also in national law. We can experience that very often. I will very much develop on international environmental law and some related norms. We have a traditional array of tools ranging from compliance control exercised by a state or an entity. There are occasionally one well-known instrument is environmental impact assessment. The International Seabed Authority has developed a new mechanism, which is hardly known. It's not yet enforced, by the way, namely the environmental development plan, which an applicant has to submit as a part of an application for deep seabed mining possibilities. This is a self-commitment, and I mention it not for the reason that it's new, but it shows a certain new tendency which we also have in the Paris Convention, namely a self-commitment. Only if you fix your national targets, the state, then they become law. And this is a development one should further look into, for it has certain consequences. Apart from that, we have a traditional system, namely the reporting system, which we all know from human rights treaties. It has been criticized by many, but if it is being implemented properly, namely as a dialogue between the treaty body and the state government, vice versa, and in some countries these reports are discussed in parliament, then this reporting system is much, much better than it has been declared by some academics. Whether the investigation done by the Atomic Energy Agency, it's also an issue which is of relevance in the Ukraine conflict, is helpful or always effective. It is a question which I leave open. There are enforcement mechanisms. We traditionally distinguish between confrontational and non-confrontational enforcement mechanisms. Sanctions stand for the confrontational enforcement mechanisms, and very often the sanction is that a state loses its privileges, such as a membership in an international treaty, for example, the European Human Rights Treaty. Is that really an effective, a useful tool? For by that one gives up the control over the state concerned. Therefore, I have my doubts that this is always the best way of doing things. It's rather to keep the pressure on that state within the context of the treaty which has to be implemented. Another measure, again going to environmental law, is sanctions on the side of economics, trade sanctions, etc. Some treaties provide for that, such as the Montreal Protocol. Others don't, and very often, and here I come to a weak point, states unilaterally impose their national law upon other states, pretending or believing that this is the international standard. This is a question we should be more careful and think about it, whether this is really the right way of pursuing international law. The treaty body of the International Covenant for Economic, Social and Cultural Rights has rightly criticized some states' sanctions in respect, in this case, of the Iraq. On targeted sanctions, I will not speak, since there is enough written about that. And I would rather like to go into another question, which is perhaps a little bit beside the point of wars, but nevertheless very much in the interest of protecting the world climate. Namely, how do we ensure the new regime on climate protection? In this respect, the international courts and tribunals have so far not done that much. Whereas at the national level, we have quite some jurisprudence. Still, the International Court of Justice, for example, has, on a different aspect, very much emphasized that states are able and should be engaged in the protection of community interests. I'm referring to the case, the Gambia versus Myanmar. I know not everybody in this room agrees of what the reasoning of the International Court of Justice. I leave that open, it's documented. But I believe that the end result of this case, of this order and the judgment, I personally agree to that. It's not very important. But I believe one could have improved upon the reasoning. Robert Kolb already referred to Article 48 of the Articles of the ILC, which could have been included in this respect. But let me, what I said before, invoke the question or bring up the question, how much can be done by national courts or international courts in respect of the fight against climate change, etc. You can also use it in respect of pandemic diseases. Question number one is, which state can act on behalf of the community, international community? Who is the international community? And what is the status of that state? In the case of the Gambia, for example. Is the Gambia protecting its own right? Is it protecting the community interest as kind of an agent? Or, as the International Court of Justice explained, as a member of a treaty body? All these three approaches are in themselves reasonable and logical, but they have certain consequences procedurally. The ICJ did not really establish the point, the status of, in this case, the Gambia, but it declared that the Gambia had standing, and this was explained. What is not sufficiently considered, I fear, that national courts face the same problem. And here the answer is not as clear as the answer was in the case of Gambia versus Myanmar. For example, is it possible that a group of individuals can claim that a certain entity, in this case I will start with the European community, yes, that the rules of the European community do not live up to the obligation of the European community in respect of climate change? In the so-called people's case, the European Court of Justice said there is no standing of this group. They are not victims, period. And this has been confirmed. Now look into what the German Bundesverfassungsgericht, the Constitutional Court, has said. The German Constitutional Court, facing practically the same factually situation, argued, yes, this group has standing. Now, why? The reason was, so it was explained, that, and this touches upon which is coming up later, yes, the humanization of international law, that the petitioners had the risk that their health, their dignity, their property would be violated if the German government would not improve upon the law concerning climate change. And therefore, the rules were declared to be in violation of the German Constitution. Here you have one side and the other side. Since I've received a signal, I will drop the rest and just come to a conclusion. The conclusion is the following. We must first think about judicial settlement on the use of dispute settlement instruments, not only of international courts, but also of national and regional courts. They should be considered a unit, first. Second, one should also accept that individuals have the right to claim, to defend themselves against future risks, and they act, in my view, not as individuals, but in a dual situation, as individuals and as defenders of public interest. Therefore, this is a case of actio popularis, also mentioned by Robert Kolb, and there should be more harmonization between the national court system in this respect and the international aspect. And finally, we should stop differentiating between treaties, properly speaking. Also, the compact against illegal migration should be treated as an international instrument which is enforceable and legal binding and enforceable. And therefore, our classic normative system should be broadened, including also instruments which are perhaps not legally binding, but politically binding. Thank you very much for your attention, and I'm looking forward to a vivid discussion. Thank you, Mr. President.
Thank you very much, Professor Wolfrum, and I apologize for playing a bad role.
That's your role.
And I wonder if it's still a moderator in this respect. Not sure. La parole est à... You have the floor, Mr. Wimmingia.
Thank you very much, President Daudet. Your Excellencies, friends and colleagues, and ladies and gentlemen, it's a considerable honor that the Curatorium of the Hague Academy has invited me to speak on this opening panel of the Centenary Colloquium. The grandeur of the occasion is matched by the enormity of the topic assigned to this panel. I'm very grateful to the organizers of the morning panel because the sleep-inducing effect of a jet lag is less severe in the morning than in the afternoon. But another thing, interesting thing, is a question to Professor Tubina, because at the beginning, when I was given this topic, I thought it was a mistake. Public interest in international institutional law is immediately obvious to me that it has a very narrow scope. I thought he meant public interest in public international law. So we have a parallel topic from Professor Nishitani later on about the private international law and public interest. But the more I looked into the materials, the more sense I saw in the course of preparing for this paper. Now my task has become to make a long speech very short, considering the time restraint. The first thing first, so the topic is about the relationship between public interest and the law of international organizations, or as also commonly known, international institutional law. It appears to be unattractive in literature, as shown in some of the leading textbooks on this branch of public international law. If you look in Philip Sand's and John Clapper's textbooks on international institutional law, you would find no reference, basically, to public interest. So that's intriguing for a start. Nonetheless, there's no denying the present topic entails a consideration of important topics with practical implications, because public interest can determine the development of international institutional law and international organizations themselves. So my talk will cover 5 points. I hope I have enough time for all of them. The last one, the fifth and the last point, is the conclusion, but with substance. The first point I want to talk about is the meaning of public interest in the current context. And during research, I was surprised to see political scientists treat this term public interest as unique to the political rather than the legal system. They think this term is inappropriate for legal system. But on the other hand, other literature will show that the term certainly occupies a prominent place in the administrative laws of France, Belgium, and Greece, to name but a few. So even from the perspective of general principles recognized by civilized nations, I think there is a value to look into it. In international legal writing, the term has two let's say, sister notions, community interest or common interest. Yet this interest is short of a right in legal proceedings. We all know when you have a legal interest at the state, you can apply for intervention in front of the International Court of Justice, but that's only a matter of interest, not a right. In the law of international organizations, a common interest makes better sense if it is understood as a one shared among the member states of the organizations. So the basic proposition of this paper is that the public interest being considered here is that of the member states to the organizations, and may expand in scope to include public interest of all states comprising the international community. My preceding speaker already mentioned that, but I'm not going to enter into a debate about the international community. If there is one now, like at the present, I think it is one primarily of sovereign states and their organizations. So I'm trying to start from a very low point so that I can manage the size of the talk. The meaning to be adopted here for public interest is to be distinguished from another one, commonly associated with public interest in domestic legal terms. I try to distinguish the term I'm going to use here from the one which goes to the public curiosity. So general public will have an interest in the working of international institutions, but up to a point, because of the considerations of confidentiality. You don't have access to the inside information of international institutions, and it's quite tiring for you personally to collect and analyze data regarding a large number of international organizations. It's impossible. What I'm going to adopt as the term public interest in this context is this one. So the connotation of the term signifies common interests as a generative of and protected by international institutions which have found their way into the constituent treaties and decisions or binding resolutions of the organizations. This is an essentially treaty-based public interest, and it constitutes the main focus of the paper. But before I use it, I understand that there are lots of the gaps here in knowledge, in my knowledge about the topic. So I try to hedge the risk. So there are 3 qualifications here I want to put forward to qualify what I have said, what I have suggested as the concept. Firstly, the rules of a public interest are likely to be as controversial and uncertain as the rules of use cogents. We all know the notions of use cogents and public interest, but tell me which rules are of public interest. It's difficult. And secondly, I try to draw a distinction between the public interest of all states comprising international community and that of the states parties to the treaties establishing international organizations. So for the treaty parties, there is a erga omnes partes relationship, as mentioned several times by the International Court of Justice, but sometimes the treaties themselves will branch out, will reach out to other states in the world. I come back to this later on. And thirdly, while this paper is concerned with the relations between public interest and the law of international organizations, it goes without saying, rules of a public interest also exist in other treaties, which are not concluded for the sole purpose of establishing international organizations. A good example, the Great UNCLOS, Law of the Sea Convention, Article 17, provides for the right of innocent passage for all ships, for ships of all states in the world. So it gives rise to interesting queries about the scope or the range of the beneficiaries. So you have the states, whether they're parties or not to the Law of the Sea Convention. You also have the group known as the shippers, the ship owners. You have the crew, you have the passengers. Do they also enjoy the right of innocent passage, for instance? But I'm not going into detail here. So that's more or less the first point. And the second point is about whether international organizations were created was created kind of at the initial, if you like, with public interest in mind. The answer, based on state practice, is affirmative one. So from the very beginning, we know late 19th century, you had a glimpse of the future international organizations established in Europe, for Danube and for Rhine. And the main purpose then, as it is today, the organizations were established to facilitate international cooperation. That still remains the basic rationale for today's international organizations. And once the organizations were established, the organizations will be mandated to, sorry. Oh, there I got a warning. I have 1 minute left. Or perhaps Professor Wolfrum has used up my 5 minutes early on. Anyway, so I think that's rather tight. Since the paper will be published online, so I guess once I have a better draft, this is draft one, you can have a look, right? I go straight to the final one, the final conclusion, okay? So after the reading and the research and writing, my impression is that for future international organizations, they will probably adhere to the classic way of organization making. in the sense that they will be anchored to treaties in future. Nothing will change in the foreseeable future, not only because of international law, it's the only normative order that can be called legal order. Unlike other normative orders of ethics or politics. And then once you have a concern which matters to all the states in the world, you need all the states to come on board at the same time. And that's the attraction of multilateral treaty making and framework treaty making. That's the value of it. So in the future, international organizations will continually build on international treaties. And another remark as by way of a conclusion is that maybe we will discern public interest more easily by looking at the public policies emanating from international organizations. I want to explain more, but I guess I have 2 seconds left. So thank you very much.
I'm very sorry indeed, but we have to keep time for discussion. So I apologize, but that's the game. You have the floor, Professor Nishitani. I would like to indicate that you are the new vice president of the curatorium of the Academy, elected yesterday.
Thank you very much. Your Excellencies, ladies and gentlemen, it's a great pleasure to be here. Thank you very much. My topic is public interest in private international law. The Westphalian system presupposes a strict public-private divide. Public international law is grounded on consent of states and sovereign equality. Private international law aims to localize cross-border private law relationships in the state that has the closest relationship. This perception starts to change. We live in an increasingly interconnected and transnational society. Sovereignty is gradually eroded. State functions are partly taken over by international organizations, NGOs, and other actors. Legal sources multiply. The public-private divide starts blurring. Private international law is no longer limited to a value-neutral allocation of state jurisdiction. It can contribute to global governance in tandem with public international law. Public interest is understood as community interest or general interest shared in global society. In a broader term, it relates to human rights, climate change, pandemic, and market regulation. In seeking public interest, voices of developing countries should be heard, as the adverse effects of human rights violation or climate change are more strongly felt by them. The goal should be shared responsibility between the global north and the global south. I use here the term global north and global south, which are a little bit ambiguous, but I refer to them to indicate developed countries and developing countries in general, respectively. In pursuit of public interest, establishing multilateral cooperation is the most efficient way. To give effect to the UN Convention on the Rights of the Child, the Hague Conference on Private International Law adopted several conventions grounded on administrative cooperation since 1980. To respect differences among legal systems, these conventions do not unify substantive rules or conflict of laws, but solely connect states for cooperation. The 1993 Adoption Convention deters child trafficking. So states cooperate and control the movement of children from Asia and Africa to their adoptive parents in Europe or the United States. The 1980 Child Abduction Convention secures the prompt return of children abducted by a parent through central authorities. So it is supported by regional human rights instruments as well. And there are also informal networks of judges, attorneys, and mediators. So multilateral cooperation serves to safeguard children's rights. In the absence of common legal frameworks, advancing public interest poses a challenge. the functioning of private international law can be induced and supported by public international law. So I take examples from business and human rights and climate change. The Bhopal explosion in India and the Rana Plaza collapse in Bangladesh show how multinationals may take advantage of developing countries. The UN Guiding Principles on Business and Human Rights provide for, besides state duty, also corporate responsibility to respect human rights. Western countries transpose this idea into their domestic due diligence acts. Due diligence acts hold the lead company of multinationals in the global north responsible for global supply chain extending to subsidiaries and suppliers in the global south. After the US has denied the extraterritoriality of the Alien Tort Statute, Europe set itself up as an alternative forum. So far, victims from Nigeria or Zambia have obtained damages or have been found to have an arguable case before the Dutch or English courts. Depending on the country, actually local courts in the global south could also be used. The judicial system is feared corrupt and biased, but once institutionalized and empowered, local courts are suited to secure access to justice for victims. It is proven by a recent Kenyan case from 2020. However, when victims decide to use courts in the global north, deference should be paid to their choice. As the UK Supreme Court decided in Vedanta case 2019, the courts should not dismiss and transfer the actions to the global south on grounds of forum non-convenience when a fair trial cannot be expected there. Notably, certain limitations inhere the method of private international law as a meta-norm. The outcome of the case depends on the applicable domestic law. The applicable law of the place of tort may not find the parent company liable. Due to the separate legal personality, the applicable corporate law may not accept the parent company's supervisory duty over its subsidiaries. The Due Diligence Act at the lead company's seat may enforce corporate liability, but only when such legislation is available there. So improving domestic law is a long way off. Still, recent English case law extending direct liability of the parent company could provide a viable solution and impact other common law jurisdictions. There may be even more innovative pathway forward. In 2020 Nefson case in Canada, victims sued a Canadian company for its complicity in forced labor, torture, and crimes against humanity in Eritrea on grounds of customary international law. So far, the Supreme Court of Canada has refused to dismiss the claims, opening that parental norms of customary international law are automatically adapted into Canadian law. So this legal construct is still controversial in civil action, but it could compensate for insufficiencies in domestic law remedies. So a novel form of interaction between public and private international law could open an entirely new field. To combat climate change, many international instruments have been adopted already, as had already been mentioned. The consensual unilateralism, however, encounters obstacles. So litigation brought by groups of individuals or individuals before national courts can help enforce state obligations. By linking climate change to human rights, litigations against the government to request more ambitious climate policy has succeeded in the Netherlands, in Germany, as has been mentioned, as in Pakistan and New Zealand. How about litigation against companies? Civil tort actions may suit the polluter pays principles. To claim tort, however, a duty of care, causal links, and damage must be ascertained. The company's small portion of greenhouse gas emissions, which is actually legal today, needs to be attributed to the loss and give rise to the liability. The 2021 Hague District Court decision is remarkable. By applying Dutch law, the court ordered Royal Dutch Shell to reduce CO2 emissions by 25% compared with 2019 levels by 2030 worldwide. This decision is certainly to be welcomed. However, it also leaves some questions unanswered, such as the content of Shell's mitigation duty, its extraterritorial scope worldwide, although only Dutch residents' interests were at stake, and causal links. In the RWE case pending in Germany, a Peruvian farmer sued a German energy company for 17,000 euros. This amount makes up 0.47% of the costs to prevent a glacial lake from flooding his village as a proportion of CO2 emissions induced by the RWE group worldwide. This claim is grounded on the victim's property rights, and legally, it is still challenging to prove a duty of care and causal links either pursuant to Peruvian law or German law applicable under the EU private international law. Yet, the private enforcement mechanism can be enhanced by continuing developments in public international law, particularly by the highly awaited advisory opinions of the ICJ and ITLOS. Now I come to my last point. In the absence of international legal framework, unilateral state regulation could be useful. There is a stark increase in unilateral extraterritorial measures. Examples include antitrust, anti-bribery, organized crime, data protection, and restrictions on imports and exports. Unlike the neoliberal globalization after the Cold War, the global pandemic and war indicate the re-emergence of sovereign states. The imposition of regulatory norms generally derives from developed countries that have a functioning market, particularly the EU and the US. Countries from Asia and Africa frequently experience market failure and are not capable of enforcing regulation. The extraterritoriality of regulatory norms, like the GDPR, imposes heavy burdens of compliance on developing countries. A balance of regulation framework between the regions should be struck. For this purpose, actually, the private international methods to allocate jurisdiction between states in a value-neutral way could be helpful. At the same time, the extraterritoriality can be justified to fill the regulatory lacunae in developing countries. Unilateral measures may be an indispensable part of transnational process, advancing public interest over time.
I'm sorry to interrupt
However,
you, Madam Nishitani. Yeah. I'm very sorry to interrupt you, but would you please conclude? You have largely over time.
Yeah.
May I ask you to conclude?
Yes, sure.
Thank you.
Yes, thank you. Yes. However, once developing countries establish their own regulatory settings to join the global market, and developed countries should no longer intervene. So it is desirable that there be shared responsibilities between the global north and the global south. So what I wanted to address in my presentation is that private international law can contribute to global governance and advancing public interest in tandem with public international law. And I think the Hague Academy will continue to play an important role to bridge both disciplines in the next 100 years. Thank you very much for your attention.
Okay, once more, I apologize for having put pressure on the member of the panel, but we are already late, Mr. May we have 15 minutes? Okay. Maybe you will have to hurry up for the coffee break. Micro, please, Madam. Sorry? Yeah, yes, please. I am asked to ask you to be brief.
So, Monica Ferria, Barrister 20 Essex. I invite the panel to engage with the following. What I mean, your thoughts certainly must be contextualized, and I wonder about the function of international law itself and the notion of public interest. Hersch Lauterbach wrote long ago a major piece on the function of international law. Maybe 20 years ago, nobody thought that international human rights law and international humanitarian law may have had something to do protecting human dignity as a common ground, as a public interest point. So I wonder, is there a notion of international law as idea of progress, or is it just a field that may take one route or another without any connection to that notion?
Thank you. We take 2 or 3 questions and then we'll have global answers. Madam.
Bonjour, Virginie Marc.
Thank you very much for your thoughts. I have a question. I would like to hear your views. Just one question, please. Yes, the international order is still quite vague, especially as regards new challenges posed by new technologies, which in fact weren't part of international public order, be it the internet or underwater cables. Public order was monopolized by private players, and I'd like to know whether the international law has taken those new needs on board, and what can international law do, and what can the international community do to broaden this scope and to introduce more sovereignty in these discussions. I would like to hear your views on those points. Thank you. Thank you very much. Question over here in the center.
Faculty is the Diplomatic Academy of Vietnam, and I have a question to Your Excellency Professor Wolfrum. You mentioned in your speech about the war in Ukraine and Sudan also. So my question is that should we look at this question of the violation of the general principle of law in a broader term, not only at those 2 cases, but other cases of war or abuse of force? And would we, after what was happening in Ukraine, try to strengthen the stricter compliance with the general principle of law, or should we let it be as a weak and loose system of law in terms of those general principles, Article 2.4 and related? Thank you.
Thank you very much. Okay. Tu veux commencer à répondre?
Thank you. Well, relatively briefly, I see a point in common with your 2 questions. There's nothing inherent in public law or public interest. It's a notion which, in fact, evolves. And by way of example, for a long time, it was thought that the progress of mankind in areas which were uncharted and where we thought that our resources were unlimited was, in fact, a notion of private law, the conquest of new continents, fishing, etc. Now we take the opposite view. We believe that the protection of species against overfishing is a public interest. So it is a notion which does indeed evolve. And Mr. Hersch Lauterbach, in the Function of Law in 1923, didn't speak about human rights, but rather the notion of the settlement of disputes and the jurisdiction of courts to settle these issues, which he saw in the interest of international communities. And there was also the issue of the competence, jurisdiction of jurisdiction. And in 1923, he identified a public interest around international law, which does not enforce its acts, does not deal with the settlement of disputes. I believe that this is still a public interest, but as you know, this also falls within the remit of state sovereignty.
I first address the question of war. You raised this question, and I would say both cases are in violation of the UN Charter. Article 2, paragraph 4 of the UN Charter is general enough to cover both aspects, although the reasons for war in Sudan and in Ukraine are totally different. Actually, what has been happening in Sudan is absolutely unusual, for it's not a war which we normally refer to as a civil war. The civil population is only the victim, not on the side of the warring fractions. However, what we should look into the matter, or would be strengthened, that there should be nothing done, now I'm speaking about Sudan, which is aggravating the conflict. There are countries on both sides which do not help to find a peace or at least a ceasefire, but rather do the opposite. I will not go into details. This obligation of states to remain outside such a conflict should and could be strengthened. I hope that answers your question. The other point is whether we should have a general rule, what is in common interest. Perhaps I'm too pragmatic and perhaps I'm too old for that. I would rather say it is coming up on itself that the law of the Sea Convention or the Paris Convention are in public or common interest is written all over these conventions. The Desertification Convention really speaks about that. Therefore, let's do that on the level of treaties. But what I wanted to say is political treaties, which are politically binding, I make that difference, should be better looked into. Thank you.
Thank you.
I have a detail for you because I didn't have time to finish my talk. So the details that the reference to all states, the phrase, appears many times in UNCLOS. That's a good sign. And then in UN Charter, it only appears once in Article 66, paragraph 1. And in Paris Agreement 2015, it appears nowhere. So when we talk about common interest, general interest, or public interest, we need to be really careful. Probably where we are still at the very beginning, formative stage of that notion. It's not settled yet. And given that if the history of international law is anything to go by, disagreement and disputes among states appear to be the immovable norm of state behavior. That's why we need the International Court of Justice and many other international tribunals. But that goes also relates to the question raised by the lady here about the function of international law, in international society today. I think there are many senior lawyers here who can answer that far better than I can do. I can imagine, really. But I tend to raise a small voice here. I'm trying to say, international as it is, it's not like the law, because of the compliance is weak. The legal system is seriously undermined up to the point of vanishing into the thin air. It's not like that. That's why at the end of my presentation just now, I mentioned future organizations will still come back to the classic way of institution building, that is by international treaties. So Article 38, paragraph 1, the sources of international law in the ICJ statute, is there for a reason, and I'm pretty certain it's going to be there forever. So that tells you, so we're talking about in the language of international law, which is a legal language. We're talking about it in a legal order. If you go outside, you can all criticize the weakness and the gaps and the problems of the international legal order. But once you're inside, you would see there are plenty of things you can do. There's a great and expensive toolkit of functions you can perform, either the lawyer or the international judges or professors or students or even the civil society. You can do a lot of things. So it's not pessimistic. Thank you.
Well, thank you. I think there was a question over there.
Oui, vous entendez, oui.
Yes, can you hear me? William Rollin, the ambassador of Belgium for the international organizations in The Hague. And I believe that it would also be necessary to hear the voice on behalf of the states, even if I'm speaking in my individual capacity. It's true that states basically are at the origin of the production of norms, but I was fascinated with the presentation by Professor Kolb. And dear Robert, you were already an unusual student in the past. And dear Professor Kolb, I don't think that you are typical scholar. I would like to raise an issue about the narrative battle. It's very widespread. May I take an example? My country belongs to the EU, which, of course, is an international organization and therefore a subject and a player of international law and projects values which are at its very core, and we believe strongly in them. But those can sometimes give rise to skepticism from the realistic standpoint, and basically people say that all of this is just window dressing. Well, I disagree with that. And I would like to add another point, and I shall conclude, and this is something that we witness the whole time in our deliberations in international organizations. We find ourselves in the post-truth world. We're dealing with false news, etc. And this has a direct impact. There are states which are forging ahead, like elsewhere in society, and put forward counter-truths to substantiate their arguments. And I believe that this, in fact, leads to a dilution of reality. We see this everywhere, equally in the relationships between states and within international organizations and with international organizations. And I'd like to know whether all of this, in fact, should be taken on board in your exchanges, and especially as regards our interpretation of what state practice is. So you may well say nothing new under the sun, that has always existed, but it has become more widespread and it is being compounded by the social networks. Thank you very much, Ambassador. I believe that this question is put to all the members of the panel, but maybe you shall give the floor to the General Rapporteur to hear his view. Well, I believe that you are right, but in reality, that is just a reflection of humanity itself, namely the Tower of Babel. The shapes of the Tower of Babel evolve over time. You have mentioned quite rightly social networks, and it goes without saying they didn't exist in the past and couldn't be used or misused to practice certain things. So yes, indeed, the narrative changes depending on personal beliefs and interests which might be defended at one time or another. And whether this has an impact on international law in the postmodern era, well, certainly no doubt, but this is no discovery. We always come back to the sources. And yesterday, I believe I was able to say to someone that we tend to forget that the first case that was brought before the Permanent Court of International Justice was something which involved the erga omnes issue. We believe that erga omnes obligations are a perfectly modern invention, but not at all. And here, likewise, we find these trends at all times. Think about Guy de la Charrière, the external politics of states, the fragmentation of international law through national prisms, defending different domestic interests. And I believe that the judges, no doubt, could say a great deal about this. They grapple with these issues the whole time when they hear different pleadings, contradictory pleadings, things. Sometimes we need to plead certain things which are really at the very limits of what we can uphold. So I would indeed tend to say, well, there's nothing new in this, but it's true that it tends to be compounded nowadays, and it's not very appealing.
I try to add something here because in my conclusion, I skipped one of the points. International organizations were continually built on international treaties, the old way, really. But the motives may have changed from, say, the late 19th century until now. So today, in recent times, we have seen the rise of the so-called minilateralism, minilateral groupings of states. For instance, a quick reference to this Commission of Small Island States on Climate Change and International Law established on 31st October 2021 was established for a particular purpose, to raise their voice in front of ITLOS, in the UN, but UN unsuccessful so far, but they're going to raise their voice in front of ITLOS to seek judicial remedy of their situation, the dire situation of survival with the climate change and the sea level rise. So we may see more and more unilateral groupings of states emerging, considering the failure these countries have suffered within the UN system so far, where you have overarching veto-wielding mechanism in place, and it's difficult to get in, basically. But with that, but I also think that it's only a tweaking of the system. It's not really fundamentally change the rationale to have international institutions in our world, because there is just so much things you need to do with your neighbors, all states in the world to get on board, to achieve something meaningful. So international institutions will remain with us, I guess, for as long as human society exists. Thank you.
S'il n'y a plus d'autres questions.
Thank you. Well, if there are no further questions. Oh, yes, sorry, over here. Another questions, the last one. Thank you.
My name is Isabel Turnbike. I'm from Greece. I'm a qualified lawyer there. I have a question about private international law and what we were discussing earlier about companies. You mentioned exactly what is happening towards the due diligence rules right now. In Europe, we're having the Corporate Sustainability Due Diligence Directive that is going to create the legal grounds in order to provide for changing that part and allowing for parent companies to be sued for those crimes. But my question would be mostly that, do you think that we're moving towards what we call in corporate law, lifting the corporate veil, piercing the veil, using those human rights and public international law to do so?
Well, thank you very much for your question. The European Commission proposal provides for the damages claim, as you say, so I hope that remains and can be adopted by the EU. In terms of piercing of corporate veil, I think the traditional concept itself does not readily allow piercing the corporate veil because subsidiaries are obviously very active in their business. So what the UK Supreme Court has started with the recent decision is going away from the piercing the corporate veil, but instead say that the parent company has a direct liability. So it's within the framework of tort law, but because the parent company is in a position to control the subsidiaries and other companies, basically because of that, the parent company is held liable. So that may be a new legal construct in a sense, but appraised by various authors and could be adapted by other common law jurisdictions, as I can see. Thank you.
Bien, merci beaucoup.
Thank you very much. We shall now have a break. I would, however, just like to thank the panelists. I believe that they have succeeded in laying the groundwork for this colloquium, and it was all extremely interesting, and I'm sure that we will continue on that course. We now have quarter of an hour, 15 minutes. I thought we were going to be given 10, but in fact 15 minutes. Thank you.